And now we have Chris Wray, who will now talk to us about DAO governance and voting processes and how they should be crafted or dealt with in any kind of future hypothetical regulation. So please, Chris, the floor is yours.
Thank you. I will do my best to stand in for Silke, who can't be here, and it's very hard to substitute for her depth of knowledge, but this area is of particular interest to me, and I think if there's one point which I convey in this short talk, it's that whenever we consider regulation, potential regulation, it does indeed go hand in hand with the structure of what is being regulated, the structure of the activity. So the setting for this panel is a very good one. What I want to do in this talk is give, with a couple of thought experiments, a couple of scenarios that I'll work through an analysis of, that look at regulation that is not just what we're perhaps most familiar with, financial markets regulation, but is going a little bit beyond and building on the question of legal personality. Because to answer the question, how should regulation address the structure of a DAO as an organization, we have to decide which structure it is we're looking at. So I'll look at both a company and partnership law case of a potential dispute between co-founders of a DAO, and I'll also look at an employment law dispute applied to a DAO. In both cases, I'm assuming here that the koala DAO model law applies. So I'm taking liberty in assuming that I'm in a jurisdiction. Currently, there's only the state of Utah, which has implemented the DAO model law, and largely in its as drafted by my colleagues in Koala. But I'll assume we're in such a jurisdiction. However, I'll also assume that English law applies because it's my home jurisdiction, and it makes it easier for me. So we're in a fantasy jurisdiction that will recognize the legal personhood of a DAO if it meets the criteria set out in the model law, but English law is applying. So our first case is that of well, perhaps first I should just say some brief comments on the DAO model law, because it is very relevant here. The aim in drafting it was not to assume that it could at a stroke solve all outstanding issues of regulating DAOs, but rather quite a focused aim, which is to say that the incorporation as a concept and as adopted in jurisdictions around the world provided a base on which other kinds of organization and other kinds of regulation can be built. But the requirements of incorporation are fairly limited. So there's nothing to stop in many jurisdictions a limited liability company being incorporated in which, whilst there may appear to be a diverse body of shareholders, in fact, multiple of those shareholders are ultimately controlled by a single beneficial owner or controlling owner. And whilst there is further attempts at regulation to try and uncover those, it's not an easy thing to do. So it's not that incorporation is trying to, in itself, solve the full range of issues, nor would implementing something like the DAO model law address all the issues, but it's a good starting point. So let's assume we have a group of co-founders who wish to start a DAO, and they will come together and discuss ideas and figure out what it is they want to do. And they will achieve recognition as a DAO under the terms of the model law, which are, as for incorporation, are primarily requirements or formalities of registration and of reporting. And the aim in the model law is simply to find functional equivalence or regulatory equivalence using technological means to what would be the traditional reporting requirements and incorporation formalities for a company. So they, and maybe just a few more comments, but what are the fundamental issues that registration requirements and reporting requirements address? Well, it's fairly fundamental tensions that arise in a collaboration. So you're always going to get a principal agent potential misalignment arising as an issue if those who are making decisions are not identical to those whose funds are at stake, as you would have in a company. And so that's an issue that needs to be addressed. And you can immediately see how in a situation where, well, actually every token holder, every shareholder has the potential to vote on issues to an extent that is more frequent than in most companies, where shareholders are very rarely deciding issues. Even if it's not in practice in DAOs today or in the foreseeable future truly going to be every issue, but nonetheless, you can easily see how this particular technology provides a way to address the same concern that certain registration and reporting requirements were trying to address. Minority protections would be another fundamental issue that are at stake. If you have a majoritarian basis for decision making, then it becomes possible for those who control a company, and perhaps even where that principal agent protection has been engaged, so perhaps shareholders need to approve a particularly consequential decision for a business that the directors are pushing, but nonetheless, 51% of those shareholders, or it might be 75% as a supermajority, they can still push through a change that will very much unfairly be to the detriment of the minority. And so you find in English company and partnership law, for instance, the kind of minority protections that I'm going to discuss in this first case. So let's get to the facts of this one. So we have our co-founders. They've created their DAO. They're effectively a startup, but instead of raising funds from angel investors and seed stage VCs, they've raised through a diverse set of crypto investors who've exchanged cryptocurrency for a governance token in the DAO. So we now have a much larger group of token holders, but in this case, we have quite a common occurrence, which is some of those co-founders or core team will have substantial concentrations of voting power, of token holder power. But in this case, what I'm going to explore is not so much the minority protection for that long tail of smaller token holders, but actually minority protection around a co-founder who is pushed out. After some time, say 4 of the 5 co-founders decide they don't want to continue working with the other, and they push this individual out. Now, if this were a company, you might be surprised to hear that even under English law, in a jurisdiction where you're used to the strength given to parties. Well, to the extent that they're parties with equal negotiating power, they're allowing them to really negotiate whatever contractual agreements they like. And so you might think that in England, if you started a company and very clearly negotiated a shareholders agreement that very clearly sets out the way in which decisions should be made, algorithmically, I might say. Nonetheless, if on the same facts, one of 5 co-founders was subsequently pushed out by the other 4, fully in accordance with the shareholders agreement, fully in accordance with the Companies Act, such that that person was no longer participating in the management and the activity of the business. They wouldn't be able to have their shares taken away arbitrarily, although by being pushed out, they might thereby stop gaining additional shares that were still to vest. So it might impact their financial interest, but primarily they're pushed out. That individual would be able to bring, notwithstanding the shareholders agreement, a unfair prejudice petition, and potentially ask an English court to override the contractual basis of that agreement from a consideration of equity, the fairness of the situation, and, for instance, provide a remedy such as either compelling the majority to buy out the minority, or forcing a dissolution of the company and a liquidation of the assets so that it can be distributed to all. Even in England today, regulation has this way of surprising you and coming in and attaching to a situation where you thought you had absolute clarity about the basis on which the decision-making procedures would lead to an outcome. So, what does this look like under the DAO model law? Well, it's interesting because, as written, it might well give greater clarity to the extent that it attempts to exclude some of these considerations that come from equity. So the DAO model law is very clear that none of the participants, whether it's a member of the DAO or has someone who's been given a specific role by the DAO, none of those should be considered as fiduciaries of the DAO. There should be no fiduciary duties attaching to them unless they've either taken it upon themselves by holding themselves out as a fiduciary, or the DAO bylaws, its sort of constitution has specifically attached fiduciary duties to that role. So there's an interesting question there, whether that alone might prevent an English court attaching this additional fiduciary duty, this additional equitable duty on the majority of the co-founders not to push out the minority co-founder. So really my illustration here is that even in a very simple situation, this isn't very complex regulation. We're still looking at how do the people intimately involved in collaborating around a DAO, how do they carve up the work? How do they decide what they will do? Even in this situation, regulation can bite. But actually, interestingly here, potentially we have greater clarity from something like the DAO model law. And when it comes to remedies for this kind of situation, it's quite interesting to see that something like rage quitting actually provides a ready-to-go equivalent to what a court might otherwise have to order in a very costly and unwieldy way, forcing a buyout, trying to fix what the valuation of the buyout would be, or forcing a liquidation, a dissolution of the company, or a liquidation of its assets in order to provide a remedy. Well, it looks like there's been to some extent, a kind of liquidated damages, an attempt to, in advance, decide what the appropriate remedy is in this situation. And I think that would count with an English judge, at least, at seeing whether equity would require implementing one of the traditional remedies. So it's interesting that I can see how today, were a jurisdiction like England to adopt the DAO model law, you might already have greater clarity than you would under a traditional incorporation. But this is maybe more of kind of theoretical or philosophical interest. Let's go to the second case study, And how much time have I got, by the way?
Well, officially 2 minutes, but we can make it 5.
Fine, okay. Second case, employment law. So let's say we have a core team member. And I appreciate that it's often a conceit of DAOs that truly everything is a market. The DAO is somehow spontaneously establishing the dependency graph of all the different things that need to be done to achieve its objects. And so they can all just be put up for bounties in the marketplace, and different DAO members will take these things for a fixed fee, or perhaps with a retrospective reward, and that people will participate in multiple different DAOs, so that it looks very much like a market. It's a market type of interaction. It's a contractual interaction fundamentally. So the contributor to the DAO is to be treated as an independent contractor rather than an employee. But nonetheless, in most of the DAOs I'm familiar with, there do tend to be a core team. There are some people who are just passionate about a particular DAO, and they're not spreading their time over multiple different DAOs. They're in fact giving the majority of their efforts to this particular exercise. And let's say we have a core team member who's been there for a couple of years, and then they're pushed out. They're fired effectively. Maybe they fell out socially with one of the founders. And under English law, if the criteria were met, this person could potentially bring a claim for unfair dismissal. So we've got a new kind of regulation is coming in and biting, and what it will attach to will depend on what structure is there. And there's no question to my mind that an English court looking at this kind of case would not say, oh, the structure that I see is only completely flat token holders voting on things. In practice, we have an employer here, and so there is a relationship of employment between this particular employee. So a court is going to look into that internal organizational structure that goes beyond that which has been reduced to the bare technicalities of voting power. So, and I apologize for not saying more about voting, but I guess my point here is that decision-making in organizations, including most real DAOs today, goes much beyond simply the aggregation of inputs from DAO members that you might call votes. It goes beyond that. There are always additional information processing and decision-making mechanisms at play. So we do need an approach that looks at the full social and legal and technical picture to understand how our decisions are being made, who is making those decisions. And then it will be an interesting question. Was there a process which looks like the possibility of an appeal under English statutory employment law for this person who was pushed out? Well, for that even to be possible, the DAO will have to have a certain minimum structure to be able to say, yes, the person who heard your complaint about having been dismissed was indeed somewhat removed from the person who made the original decision that you shouldn't be there. You would have to show that structure to be able to defend yourself. So wrapping up very quickly, what I see here is that while legal personality and limitation of liability is really the starting point in terms of the structure as it goes to regulation, additional structure is going to be needed to address all of the different angles from which regulation can come. And whilst, of course, there will always be those who want a very pure, there'll be dark DAOs where it's fully anonymous, and perhaps even what they're trying to achieve is so simple, it is just make a number go up. It's so simple that they need actually very little structure to achieve that aim. You really can have a situation where all DAO members independently align themselves towards some objective function. But that's not most of human collaboration. Most human collaboration is much more complex than that, much more structured. And so that structure will be there if we're doing interesting things, which I hope we are with this kind of approach. And once that structure is there, regulation will rightly try and attach to it. And so the future I see for DAOs here will be equivalents to the DAO model law for additional extensions of regulatory structure and regulation, so that it becomes clear what is the correct mapping from what a regulator expects in terms of the regulatory affordances, you might say, of an organization, and the genuine complex internal structure of the DAO, to find that mapping and to show how the technological means are actually providing equivalent, function equivalent or regulatory equivalent protections, or otherwise addressing the same policy ends that the regulators are imposing.
Well, thank you very much, Chris, for this great presentation.